These it?
Yeah.
I have them.
Mike, you got them?
Yeah, I think that's the default judgment.
Which one's first?
They're both separate, same
They're
time.
both the same. Good.
First American Title Insurance Company versus Euless Wilson, 45 CO1, 1309 PL 95.
Good morning, Your Honor.
Morning. A motion for a default judgment. Do we have service?
Yes, Your Honor.
Where's your proof of service?
They actually, defendant filed a motion for extension of time in this matter, and that's come and passed.
Okay. Let me see. I don't see that. You mean he filed a motion after your motion for default?
No, he filed a motion for extension of time to answer the complaint. I believe he appeared pro se
Oh, okay.
and filed a motion for extension of time to answer the complaint. And that extension of time, that deadline passed. I sent him a letter advising that we'd be seeking a default judgment. So he was on notice. I allowed time, and then I filed for the motion. I filed the motion, Your Honor.
All right, file for a motion for a change of judge. See that? Judge Snyder.
Maybe that's what it was, Your Honor. He filed for a motion to change a judge, and then once the file got transferred, and then the deadline for his response still passed.
Well, I mean, did he receive notice of the transfer?
I didn't file for the transfer, Your Honor. He did.
I know. Let's see. Okay. So they gave him regular mail. Counsel, we need to make sure he gets served. I mean, he's a pro se defendant.
Well, it's my understanding that he was served by certified mail on June 21st of last year.
Of the complaint.
Of the complaint. And then he appeared and requested a change of judge.
So notice by mail is sufficient. Is that what you're saying?
Well, I mean, he was.
I mean, did you get notice of your default judgment?
I sent it to the address that we served with the complaint, the summons, and then he appeared in this case and asked for a change of judge. He didn't file a notice of change of address with the court, so I served him with a copy of the default judgment in accordance with the rules of trial procedure. It's his obligation to update his address with the court.
I agree with that. All right, operator, we'll grant the default.
Thank you, Your Honor.
What's the date? 11?
11.
Okay. Town of Cedar Lake versus Lake County Trust Company et al.
Morning, Your Honor.
Good morning. Are you appearance today, Mr. Munich?
Already entered the clerk's office. I believe.
All right. All right. All right, we're here on strike notice of objection to
Yes, sir.
Okay. We're ready to proceed?
Yes, sir.
Sir, are you represented?
No.
No, sir.
Give me a little synopsis of
Yes,
what
sir.
we're doing.
This is a proceeding in eminent domain condemnation under the Indiana statute. The court has already entered an award. The appraisers have made a report. The funds have been paid into court, and the clerk has filed her certificate the property has been taken under the statute. On October 29th, and after that, about 32 days after the award and the appraiser's report, a party unknown to us filed a notice of objection to amount of award by court-appointed appraiser. The document is not signed. It does not show on behalf who it is filed, and as a result, the town is in somewhat of a difficult position because there are several named defendants, some of which may be real parties in interest and some of which may not. We don't know. But without knowing who filed the objection and without the objection being signed, the objection is attached as an exhibit to our motion. I believe it was filed on the court's docket on October 29th. It's a simple one-page document with the clause number, the caption, the notice of objection to amount of award by court-appointed appraisers, but it does not identify who is filing the objection. It is not signed by any particular party, and the trial rules are pretty explicitly clear that the document, especially in the case of a pro se litigant, must be signed and identify the party upon whom it is signed. But without knowing who we're, I won't say fighting with, if I don't know who we're going to be going to trial with, we can't very well proceed either with discovery or any other proceedings. We think the objection is fatal and should be stricken.
Did they give any of what the objection was?
No, it simply says,
I see it here.
it simply says, please set it for trial. Now, I will concede under the very liberal interpretation by the Court of Appeals as to what constitutes a legitimate objection. It probably works. The difficulty is we don't know who's filing the objection, it's not signed, and we don't know who the real party in interest is.
Okay. Was the objection timely filed?
Yes, sir, it was. 32 days. The statute provides 45.
Okay. Sir, are you the people objecting?
Yes.
No, I'm not. You're not objecting?
Can I speak, Your Honor?
Yes, please.
Okay. I'm the owner of 11114 West 130.
And what is your name, sir?
John Pogoric.
Okay.
I don't even know why I'm in this because I'm the owner of the property, and I agreed to the town of Cedar Lake that I agreed with this project. They offered me the money,
But you accepted it?
I accepted it, but we're on the same trust And what happens is the trust, she's on the same trust, I'm on the same trust.
So you accept it and she doesn't? Is that what we're...
Well, even that's not accurate. There's a third party, my ex-husband, and he was the one who objected to it. The objection was filed. He actually is the one who filed the objection.
He's the one who filed this, what we have here today?
Yes.
Where's he at?
He is out of the country. We are both very willing to sign the original offer.
All right. Motion to strike is granted. You can proceed with the... He's
Do you wish me to file a form order or the court?
Yes, would you file an order?
But so then what happens? Do we have to take the offer that the appraisers gave, or can we take the original offer that was made?
I don't know. Well, that, I don't know.
That you probably give me an answer. The problem we've had, the town has had with the inception of the litigation, anecdotally, we understand that Mr. Pagoric is either a contract purchaser or has acquired the real estate through contract. He is not a named, he is a named party in our litigation because we picked up that anecdotal information, but he is not the holder of record of title. The holder of record is the Lake County Trust, I think 4853. That's been one of the problems we've had from the inception, I don't believe there's any great dispute between these two parties. The problem is Mr. Bennett, and Mr. Bennett has been, for lack of a better term, throwing a monkey wrench in the proceedings from the beginning.
If I could interject, sir, I am the beneficiary of the trust, and I found out that I have the absolute right to sign for the trust. So I will sign against his wishes if the court would allow that.
Well, he's the one that's not here.
He's the one that's not here. Now, he's stricken it.
Yeah.
My only concern is that when the proceedings are done, we have something that's very clear on the record. I can't give them advice, but I would suggest that they go to the trust and ask Ms. Sievers, who's
no longer there.
She's not there anymore?
No, she retired a year ago.
There we go. Anyway, whoever administers the trust, I would suggest to them, without giving them legal advice, that they contact the trust and then the documentation, because they are the owner of record according to the title report. If the trust, as beneficiaries of the trust, they're prepared to direct the trustee to accept the judgment, we can get this cleaned up and go away. But I can't give them legal advice to do that.
And I'm more than willing to do that. We just want to be very clear that we want the offer that offered Mr. Pagoric $20,000 and me $6,000.
We're in a position to do that any longer, ma'am. I can't. I'm stuck with the award of appraisers and the certificate that's been issued. The funds have been paid into court. The certificate's been issued. I believe we're at the termination of the litigation at this point.
What's the difference between the offer and what the appraisers came up with?
That one I don't.
Like $10,000.
Judge, if I may.
Oh, I'm sorry. This is Mr. Adam Ford. He's an associate.
Daniel Ford.
I'm sorry, Adam. That's what happens when I've been with the firm for 30 years.
Yesterday I spoke with head town attorney Dave Austin, Judge, and he wanted me to advise the court to have Mr. Pagoric give him a call today or tomorrow to discuss what terms will be offered going forward with the eminent domain proceedings, whether it be the original appraised price or the newly appraised price by the appraisers. So that's the information I have.
Okay.
And we have contacted him prior to this, and he told us to come to court.
Well,
we made the offer to sign the $20,000 and the $6,000.
We had to do it in that fashion until this matter of objection was raised. I certainly have no problem with them conversing with Mr. Austin at this point.
So now you can converse with Mr. Austin. Mr. Munich will file a form order.
Yes, sir. 7 days?
Sure.
Thank you.
Okay, do you understand everything you need to do now?
Okay, so we just have to deal with Mr.
You
Austin.
deal with Mr. Austin, and as far as the court's concerned, this matter is pretty much concluded.
Yes, sir.
Thank you, Robert. Thank you very much.
Yeah, ma'am, why don't you state your name and spell your name so for the record.
Deborah Rodriguez.
And you, sir?
John Pagoric, P-A-G-O-R-E-K.
Okay. Thank you.
Thank you, Your
Thank
Honor.
you.
Okay. See that, Mike? How fast that was?
Nice, man.
Huh?
That's nice.
Yeah. Well, them casinos are hurting, Mike.
That's what they're saying.
Huh?
That's what I heard.
Shit, they're down like $30 million. So you know what that means? They're gonna pay off a lot less, buddy. You see that girl that hit that thing in blue chip and they wouldn't honor it?
Really?
$28 million.